waiting for Chairman Johnson. He is on his way, and given that we lose the room shortly, he's cleared us to go ahead. I'm delighted to recognize my original co-sponsor here, Senator Blumenthal, and also Congressman Cicilline of Rhode Island and Congressman Jones, who have legislative measures that are incorporated into this bill. Let me start by saying that you can't understand what is happening at the Supreme Court unless you understand the concept of agency capture. And I will leave that to all of you to figure out, because there is an abundant literature in the field of economics and there is an abundant literature in the field of administrative law on agency capture. The Center for Media and Democracy has reported that the spending on the effort to capture the Supreme Court has hit $580 million. So this is no small effort. While it is not small, it is very secret. We can't trace that money back to who is behind it because it gets filtered through front groups that have managed the process of Supreme Court capture. And when you have a court that is in that predicament, transparency becomes all the more important, as recent news shows. And this bill will address some of those concerns, particularly, for instance, regarding recusals. A Supreme Court justice is now not required to address why he or she doesn't think he or she needs to recuse. And if a party thinks that they really ought to have recused, they have no recourse. Everybody knows the problem of being judge in one's own cause. The justices are judges in their own cause as to recusal. There's no penalty for getting a recusal wrong, and the level of analysis is very weak. In the case of Americans for Prosperity Foundation versus Bonta, which was a very important dark money decision, the court seems to have paid no attention to the fact that Americans for Prosperity and the Americans for Prosperity Foundation are effectively identical organizations. That is a corporate veil you could pierce with a banana. And this law would require them to look through those corporate veils. We also see flotillas of amicus briefs appear, again, from organizations that don't really exist, whose purpose is only to hide who the real interest is behind them. And they appear in flotillas of a dozen at a time, coordinated and orchestrated. And in the case of AFPF, because it was so important to the dark money operation, 50 of these organizations turned up at the certiorari stage. Another point has to do with personal hospitality. The court is now allowing its members to accept personal hospitality. I put the word personal in quotes because it's allowed to accept personal hospitality from people the justice has never met at commercial resorts and facilities. How could that possibly make any sense? So we are really pleased to be working together in bicameral fashion to, at long last, get a code of ethics and some enforcement around the Supreme Court. It could not be more timely now that we have a captured Supreme Court that needs that extra layer of accountability. And with that, I will turn to my friend and colleague in this effort, Chairman Johnson.
Thank you, Senator Whitehouse, and greetings, everyone. Great to be with you today. You know, in September of 2021, Gallup conducted a poll, and the poll results about the court system in this country were alarming. There has been a precipitous drop in public approval and public confidence in the United States court system. And the numbers for the Supreme Court were even more alarming than for the federal courts at large. And so that's why I am so proud and happy to stand here with my partner, Senator Sheldon Whitehouse, along with Senator Blumenthal, also Chairman Nadler of the House Judiciary Committee, Mondaire Jones, co-chair of the Courts Subcommittee, and also my good friend David Cicilline, chair of the Antitrust Subcommittee on Judiciary, and also Congressman Mike Quigley of the Appropriations Committee with jurisdiction over the courts. Proud to stand as we introduce transformational and comprehensive legislation that brings forward accountability for the courts and transparency for the courts. The framers of our Constitution did not, although they enshrined the principle of co-equal in the Constitution between the branches of government. The judiciary is a co-equal branch of government. But the framers did not leave it up to the court system to fend for itself. It entrusted the responsibility and the duty to create the courts, to fund the courts, and to modernize the courts in the hands of the legislative branch. And so these are changes that are long overdue. The time is now, and at this time I will yield back.
Senator Blumenthal.
Thank you. First, a great thanks to my colleague Sheldon Whitehouse, who has championed this cause relentlessly over many years, and I've been proud to join him in the work that we've done on the Capture the Courts issue, and to my House colleagues who are joining in this effort. Their leadership has been so tremendously important. This issue is timely. Couldn't be more pertinent right now. The public is watching the United States Supreme Court to see whether or not Justice Thomas will recuse himself in future cases and what action may be taken regarding his failure to recuse himself in past cases. But the issue here is much bigger and broader than one justice. In fact, it's bigger and broader than the United States Supreme Court. Yes, we need a code of ethics for the United States Supreme Court. It's no different than any other court, and all the courts in the United States have a code of ethics. The Supreme Court shouldn't be given some special pass because it is the highest court. In fact, it should have a code of ethics precisely because it is the highest court. We can't rely on the United States Supreme Court to say, trust us. It hasn't worked. But the rules here are bigger and broader on recusal. There should be standards on financial benefits that may be taken, such as travel, such as hospitality, and of course, the whole idea of disclosure is one that now is applied to all the other branches of government. We have rules we have to obey. Some of my colleagues may not like them, but they are now standard. And I'll just make one more point. If the courts oppose us on this measure, it says something very profound about them, because their resistance to the sunlight as a disinfectant ultimately will undermine the court's credibility, as well as the trust and respect that the American people have for our courts. Right now, we're in a legitimacy crisis for the United States Supreme Court. It is a crisis partly the result of the court's own self-inflicted wounds, but it is also the fact that there has been inadequate disclosure. We have been lax in our demands on the court. For decades, the United States Supreme Court was housed in the basement of this building. For decades, it was invisible to most Americans. This effort is to take the courts out of the shadows and have them follow the same rules as other branches of government so that their respect and trust can be preserved. Thank you.
Co-Chair Jones and Congressman Cicilline.
Thank you so much. Well, it's great to be with you all here today for this momentous occasion, and it's something that I think the American people are yearning for. And I'm so grateful to the leadership of all of my colleagues here today, but especially the chair of the Subcommittee on Courts in the House, Hank Johnson, and of course, Senator Whitehouse for their leadership in bringing this forward. In the United States of America, no one should be above the law. Not even judges or justices, in fact, especially not judges and justices who are tasked with administering the law. The Constitution guarantees judges, Article 3 judges, life tenure only during good behavior. But that's not what we've seen lately, unfortunately. And that's not just true for Justice Clarence Thomas. We just held a hearing on sexual assault in the workplace in the court system, and it was demonstrably clear that judges are ill-equipped and I think ill-motivated in self-policing. It is one of the various reasons why we need to enact this important legislation that we've introduced. Last year, we learned that over 100 federal judges unlawfully presided over cases they had a financial stake in. And that's just what we've learned. Over the last few weeks, we've learned that Justice Clarence Thomas ruled on a case concerning the insurrection that his wife participated in and helped plan. That's not just unethical, by the way. It's a violation of the recusal statute, for anyone who still has a question about that. But under current law, there is no way to enforce the recusal statute that Justice Thomas violated. Enough is enough. This is a matter of legitimacy, and the polling shows a crisis of legitimacy. The judiciary cannot expect the American people to respect its rulings when judges and justices do not respect Congress's laws. We need the 21st Century Courts Act, which will finally hold judges and justices accountable to rigorous, enforceable ethics standards. Yes, even Justice Thomas. As Vice Chair of the Court Subcommittee, I'm proud to co-lead this bill, and we are going to fight until we see it enacted. Thank you so much.
Congressman Cicilline has the last few minutes until noon when we lose the room, and I see my friend Senator Kennedy, who's here to make sure that we comply with the schedule.
I thought he was going to. He's here to co-sponsor.
Yeah, right. Welcome.
Come on up.
I need 3 to 5
Good afternoon. Thank you very much, everyone, for being here. I'm proud to join my senator, Senator Whitehouse, our chairman, Hank Johnson, and Congressman Jones and Senator Blumenthal, and I'm proud to be a co-lead in the House. Look, the Supreme Court of the United States, it makes decisions which affect the daily lives of the American people. And they make important decisions that impact us in so many different ways. The confidence of the American people is dependent on the belief that these decisions are made by applying the law and the evidence, and not influenced by some improper organization or interest outside of the law and the evidence. It's a bedrock of our judicial system. And as Congressman Johnson said, there are real challenges because the American people are losing confidence, particularly in the United States Supreme Court. And the legitimacy of the court is really under attack. This legislation will help to repair that, particularly in the area of outside travel, as Senator Whitehouse mentioned, personal travel as just described. But a 2000 report by the Center for Public Integrity revealed that in 2014, all 9 Supreme Court justices received free trips, with 6 traveling overseas. And according to analysis from the Washington Post, the justices took over 365 trips paid for by outside groups from 2011 to 2014. And as the senator said, this involves lodging and travel and meals and entertainment. The American people have a right to know this. And so this is about transparency, making sure that justices are operating under the strictest standards of integrity and following the rules of ethics. I hope everyone can get behind this bill and help to restore the legitimacy and confidence that the American people need to have in the courts of our country. Thank you.
Looks like we probably have time for one question if it's a short one.
Have you spoken with any Republicans, particularly in the Senate, and do you see any likelihood of being able to get any bipartisan?
We're working on it. Senator Senator Kennedy is my co-chair on the Courts Committee, and he's not there yet, but we're having continued conversations, and that's where these things all begin. I do think that there is a sense among Republican senators to whom I have spoken that it is not appropriate for Supreme Court justices to be held to a lower standard than members of Congress are and than senior executive branch officials are. The highest court should not have the lowest standards, I think, is a principle that we can get behind in bipartisan fashion. Thank you all. The room is yours, John.
Can we be part of your press?
You're welcome.